Does the law of armed conflict distinguish between international and non-international conflicts? In today's world, the question of how armed conflicts are classified is more relevant than ever. With ongoing conflicts in various regions, understanding the legal frameworks that govern these situations is crucial. Many people are searching for clarity on how the law of armed conflict applies to different types of conflicts. The law of armed conflict, a fundamental aspect of international humanitarian law, does indeed distinguish between international and non-international armed conflicts. This distinction is essential for how the rules are applied and enforced. International armed conflicts occur between two or more states. The Geneva Conventions of 1949 and their additional protocols primarily regulate these conflicts. These conventions set out detailed rules on how to treat combatants, prisoners of war, and civilians. Their goal is to protect individuals who are not or are no longer participating in hostilities. On the other hand, non-international armed conflicts take place within a single state. These involve government forces and non-state armed groups or conflict between such groups. The legal framework for these conflicts is less extensive but still significant. Common Article 3 of the Geneva Conventions applies to non-international conflicts. It establishes minimum standards for humane treatment of individuals not actively engaged in fighting. Additional Protocol 2 further elaborates protections in certain non-international conflicts. This distinction impacts the scope and application of protections. It determines who qualifies as a lawful combatant, how detainees are treated, and the obligations to protect civilians. While both types of conflicts are governed by principles like distinction, proportionality, and humanity, the specific rules and enforcement mechanisms differ. The International Committee of the Red Cross emphasizes that all parties in any armed conflict must comply with international humanitarian law. This compliance is vital to protect civilians and those hors de combat, or out of the fight. The differences between international and non-international conflicts highlight the need for tailored legal regimes. In summary, the law of armed conflict clearly differentiates between international and non-international conflicts. Each type has distinct legal frameworks that reflected the realities of warfare. Understanding these distinctions is essential for ensuring human dignity is protected in all circumstances.